Welcome again to the Rural Utah Estate Planning Resource Center. This is part 2 of our series about the different types of estate planning documents we usually see in the estate plans that we prepare. And it's about power of attorney documents. So Larry here is going to talk a little bit more about that.
Power of attorney for property management is used when you have assets that need to be managed and they're not part of the trust, such as IRAs, 401ks, or assets that need to be placed into the trust. They're different today than they were when I first started planning. In fact, when I first started planning, the power of attorney ceased to be valid if you became disabled. Now the power of attorney can continue on after your disability. There's different ways to draft it, when and how it becomes valid with disability. One of the clients once asked me, what is this document for? And I explained to them that if you were to be away or incapacitated, such as if you took a trip to the Middle East, this power would be very helpful. You'd want somebody to be able to do something. And he looked at me and says, oh, you mean like it if I went to Lebanon? I said, yeah. He says, I just went to Lebanon 3 months ago. And it became very directly related in his mind as to how this power of attorney worked. It also can be used to help plan your assets or plan your estate, modify it, create it so you can benefit from long-term care, Medicaid benefits.
Yep, and the important thing there is to get to make sure that third parties truly, and that's what we're dealing with, it's third parties, because you and I can have any kind of agreement, but it doesn't matter if I trust Larry here to manage my finances. That doesn't necessarily mean the bank's going to recognize that without this document. So we want to put third parties on notice as to who we want to manage our affairs if we are unable to, and when that's effective and to what extent they can manage that. The nice thing is this last year in 2016, the Utah State Legislature really streamlined the Power of Attorney Act for us. Before, there was a lot of ambiguity in the statute, and it caused a lot of problems in dealings with third parties like title companies and banks and any kind of financial institution as to their validity and what powers were and weren't granted. And every single form had to go to the legal department. Now that we passed this more streamlined act, we use a standard form and adapt that to the circumstance because that way the banks, especially the local banks, are much more comfortable in dealing with these forms because they know exactly what it does and doesn't grant as far as powers to these third parties. And then we can modify it from that point so that these banks only have a few lines of modifications to go through and approve rather than an entire 10 to 20 page document. If you have any questions about powers of attorney, we include them in every estate plan that we do here at the Rural Utah Estate Planning Resource Center. You can always reach us at ruralutahestate planning.com or at 435-633-6399.